Orlando Commissioner Regina Hill was just suspended from office after she was arrested and indicted for what essentially amounts to taking advantage of a 96-year-old elderly person. We're going to have a look at the executive order that suspended her from office as well as the indictment. Let's have a look. So this is the executive order signed by Governor Ron DeSantis, and the first whereas clause basically says who this person is, Regina Hill. The second one basically goes through each of the counts that she was indicted under. But this third one is kind of important. It says, whereas the Florida Department of Law Enforcement special agent in charge of the investigation publicly stated that Regina Hill became aware of the alleged victim because of her position as a city commissioner, and that because of that, she was able to lend what appeared to be some benefit services that then turned into the acts giving rise to the indictment, and agreed that Regina Hill used her position as a city commissioner to her own advantage. So there's a very specific reason why this whereas clause was included in the executive order. You see, under the Florida Constitution, the governor has the ability to suspend any elected officer who has been indicted. We know that Ms. Hill has been indicted, so he's clear under that. He's got clearance under that to go ahead and suspend her. There's also a Florida statute that pretty much says the same thing. Any elected municipal officer who is indicted under this statute, the governor has the power and authority to suspend from office. But the third statute under which he derives his authority is a little different. It says that it provides that the governor may suspend from office any elected municipal officer for malfeasance, misfeasance, neglect of duty, habitual drunkenness, incompetence, or permanent inability to perform official duties. Now, this doesn't require any finding of that. This is basically left up to the governor's discretion. So in the past, Governor DeSantis has exercised this authority under this particular statute in ways that could be looked at as not necessarily in full compliance with the law. I mean, it's arguable. So what he did when he included this this whereas clause here is he provided cover to suspend her under this particular statute. Now, one reason that he likely did that is because under the first two statutes, if the state drops the charges against Ms. Hill, then essentially he's lost his authority to maintain the suspension because she's no longer indicted. Also, if she is exonerated, if she is found not guilty of these charges, he has lost his authority to maintain the suspension. But under this other statute, he doesn't lose his authority just because the state drops the charges or she is proven not guilty. Essentially, it would require another executive order in order to reinstate her back into office. So I would think that Governor DeSantis has exercised his authority under this statute in addition to the others for that purpose, to make sure that he's the only one that can reinstate her into office. So let's move on to the indictment. Now, she was indicted under 7 different statutes, and the indictment is for exploitation of an elderly or disabled person through use of a power of attorney, exploitation through use of a position of trust or confidence, exploitation for intentional or negligent misuse of an elderly person's funds while you're caring for them, basically just common law fraud of $50,000 or more. Then we've got fraudulent use of personal identification, and fraudulent use of personal identification when you are in a position as a parent, guardian, or custodian. And then we have just mortgage fraud. So let's go through each of these different things, and we're going to look at each of the elements of the crimes to see what the state has to prove. So The indictment reads, the grand jurors of the County of Orange, duly called, impaneled, and sworn to inquire and true presentment make in and for the body of the County of Orange, upon their oaths do present that Regina Irene Hill, between on or about the 29th day of April 2021 and on or about the 13th day of March 2024 in Orange County, Florida and Seminole County, Florida, did in violation of Florida statutes. And the green is where we're going to have the elements. So it's going to go back and forth between a darker green and a lighter green to kind of differentiate between the elements of the crime. So while having a fiduciary duty to an elderly or disabled person as her agent under a power of attorney, that's element number one the state's going to have to prove. Once they prove that, they have to prove that she violated said fiduciary duty by actions which result in an unauthorized appropriation, sale, transfer of property, or receipt of an improper benefit. So that's the second element, in which the victim did not receive the reasonable equivalent financial value in goods or services. Everything that's blacked out on here is the victim's name. They're protecting this 96-year-old woman from any harassment that may come if somebody likes this city commissioner and may want to cause harm or something to this elderly person. So it's all blacked out. So we'll just refer to her as the victim. And then in red, we have not an element necessarily, but how the crime is being charged. And the funds, assets, or property involved in the exploitation of the victim is valued at $50,000 or more. This $50,000 or more level tells you what level of crime the state is charging Ms. Hill with. And we'll get back to that in a moment, though. Count 2. Regina Irene Hill did 1. While standing in a position of trust and confidence with an elderly person or disabled adult. 2. Knowingly obtain or use or endeavor to obtain or use funds, assets, or property. 3. With the intent to temporarily or permanently deprive the victim of the use, benefit, or possession of the funds, assets, or property, or to benefit someone other than the victim. And again, we have this in red, valued at $50,000 or more. Count 3, this is the final elder abuse count on this indictment. Regina Irene Hill did 1. While being a caregiver to or standing in a position of trust and confidence with an elderly person or disabled adult. 2. Intentionally or negligently. 3. Fail to effectively use income and assets for the necessities required for the victim's support and maintenance. And again, we have this valued at $50,000 or more. So why are each of these valued at $50,000 or more things in red? Well, I'll tell you, because that denotes that they are a first-degree felony here in the state of Florida. Each one of these 3 crimes, first-degree felony. Maximum sentence, 30 years in prison. She's facing 30 years in prison for each one of these first 3 crimes. Not only that, but with respect to these elder abuse crimes, we have this caveat in state law. It says, any inter vivos transfer of money or property valued in excess of $10,000 at the time of the transfer, whether in a single transaction or multiple transactions. So if there's a transaction during the life of the person transferring in excess of $10,000, whether it happens in one transaction or multiple transactions, that's the first thing the state can prove here. By a person 65 or older, that's the second thing. To a non-relative, that's the third thing. Whom the transferor knew for fewer than 2 years before the first transfer, that's the fourth thing. And for which the transferor did not receive the reasonably equivalent financial value in goods and services. That's the fifth thing. So 5 things that are on here. If those 5 things are true, then it creates a permissive presumption that the transfer was the result of exploitation. What does that mean? Well, It means that in any criminal case, this is part C, subsection C here. In any criminal case to which this subsection applies, if the trial is by jury, the jurors shall be instructed. So there's no way for the defense to get out of this. They shall be instructed, but are not required to draw an inference of exploitation upon proof beyond a reasonable doubt of the facts listed in this subsection. So if the state is able to prove each of those facts listed in subsection 2 that we just read, each of those 5 things, then the jury is going to be instructed that those can amount to exploitation, period. They don't have to make that inference, but they can. That makes it far easier for the state to prove the intent element, because they're giving the statute is giving the state the 5 things that they have to prove to get intent, exploitation. The intent to exploit is proven by these 5 things. So once you have that, it makes it easier for each of these first 3 counts to be proven. So her defense attorney is going to have a rough go of this, especially if the state is able to prove those 5 things. Let's move on. Count 4. Regina Irene Hill did engage in a systematic, ongoing course of conduct with the intent to defraud one or more person. That's element 1. With that intent to defraud, she obtained property. Whoso obtained property. That's element 2. And the property has an aggregate value of $50,000 or more. Again, that $50,000 or more thing creates a 4th first-degree felony. This is not an elder abuse one. It doesn't matter how old the person is. This is a 4th first-degree felony, so a 4th charge that carries a maximum of 30 years in prison. Moving on to count 5. Regina Irene Hill did 1. Willfully and without authorization. 2. Fraudulently use personal identification information concerning the victim, concerning the victim. That's element 2. Element 3, the victim is a person 60 years of age or older. And element 4, without first obtaining the consent of the victim. So when you use the personal identification of an elderly person, that is a specific crime here in the state of Florida. The amount of the injury of the fraud perpetrated was $100,000 or more. So this is in red for a different reason. So this entire crime, regardless of the amount of the injury, is a 2nd-degree felony, a maximum of 15 years in prison. But this red, the amount of the injury or fraud perpetrated was $100,000 or more, does something different to the crime. If the state's able to prove that it's $100,000 or more, now there's a mandatory minimum sentence of 10 years in prison. If they prove this one, Ms. Hill's going to prison for at least 10 years. If they prove any of the other 1st-degree felonies, she's going to prison for somewhere between 10 and 30 years. She's 58 years old. 30 years in prison is going to be, she's going to be 88 before she gets out of prison. If she gets the maximum sentence. Count 6. Regina Irene Hill did willfully and fraudulently. That's the first element. Use the personal identification of the victim while exercising custodial authority over the victim. 3rd element. And the victim is a person 60 years of age or older. So this is essentially the prior one, but without $100,000 in there. So just 15 years in prison for this one. No mandatory minimum, no nothing else. 2nd-degree felony. She gets off easy if this is the only one that she's convicted of. And the last count is mortgage fraud. Regina Irene Hill did. Now, there's a bunch of ors in here. So when we go through this, there are two elements of this crime that apply to all of the or statements. And that is with the intent to defraud and knowingly. So the state has to prove that Regina Hill did this crime knowingly and with the intent to defraud. Now we're going to go through pairs of elements that go together and then are connected by an or, which means once you get to that or, now they don't have to prove those prior ones, only have to prove the next two. So first, making any material misstatement, misrepresentation, or omission during the mortgage lending process. That's the first element. Second, with the intent that the misstatement, misrepresentation, or omission will be relied on by a mortgage lender. Or, 1, uses or facilitates the use of any material misstatement, misrepresentation, or omission during the mortgage lending process. 2, with the intent that the material misstatement, misrepresentation, or omission will be relied upon by a mortgage lender. Or, Regina Hill received proceeds or any other funds in connection with the mortgage lending process. 2, that Regina Hill knew resulted from a knowing material misstatement, misrepresentation, or omission during the mortgage lending process. Or, 1, filed or caused to be filed with the Orange County Comptroller, acting as the clerk of the Circuit Court of Orange County, for the recording of a document involved in the mortgage lending process. That's element 1. You filed a document with the court that's involved in the mortgage lending process. 2, which contains a material misstatement, misrepresentation, or omission. So there's 4 different sets of elements that the state can prove here. And as long as they prove any of those pairs, plus that it was done knowingly and with the intent to defraud, they've proven the elements of the crime. And then we have how this crime is being charged. And the value of the loan stated on the documents used in the mortgage lending process exceeds $100,000. That makes this a second-degree felony. And again, that has a maximum sentence of 15 years. So with all these crimes, she's basically being charged with 4 crimes that have a maximum sentence of 30 years, 3 more crimes that have maximum sentences of 15 years, and 1 crime that, if proven, has a mandatory minimum of 10 years. So she's facing anywhere from 0 to 30 years, and if that 1 crime is proven, 10 to 30 years in prison if the state proves its case. Let me know what you think in the comments below. If you haven't, check out my other video on this topic where we essentially go through some of the things that are being alleged that she used this money for. For now, my name is Nathan Saunders, and this is The Legal Good.